In this video, I'm going to talk about going to trial in the Magistrates Court in Queensland for a criminal offence. Strongly advise you get legal advice before deciding to do that. Going to trial means you're pleading not guilty to the charge. You're saying you did not commit the offence. In the Magistrates Court, a magistrate hears the evidence presented by the prosecution and decides if you were guilty or not guilty. Unlike trials in the District Court or Supreme Court, there is no jury. The trial is also less formal than a trial in the District or Supreme Court. Now, what happens at a summary trial, you may ask? Well, firstly, you enter a plea of not guilty. The magistrate will read out the charge to you and ask you how you want to plead. If you are contesting the charge, you'll need to say, "Not guilty, Your Honour." Secondly, the prosecution will present their case. The prosecution will start their case. The prosecution will call each of their witnesses one by one to give their evidence. The process in which this occurs is as follows. 1, the witness will be asked to sit in the witness box, which is inside the courtroom. The witness won't have a copy of their police statement with them, generally. And the witness must give evidence from their own memory. And they can't refer to their witness statement unless they're given leave by the court to do so. And this is rare. Secondly, the clerk of the court will ask the witness if they want to take an oath on the Bible. That means swearing on the Bible that the evidence they will give will be true, or they'll take an affirmation affirming to tell the truth to the court. Either way, it doesn't make any difference. Thirdly, the prosecutor will ask the witness questions, and this is known as examination in chief. When the prosecutor asks a witness questions, they cannot be leading questions. A leading question is a question suggesting the answer to it. For example, if I said to you the car was blue, wasn't it? I'm suggesting to you that the car was blue as opposed to any other colour. After the prosecution has asked a witness questions, the defence may ask the witness questions. This is called cross-examination of the witness. When a witness is cross-examined, they may be asked leading questions. When the defence asks the witness questions, they may also suggest things to them. For example, defence may suggest to a witness they didn't see everything as they say they did. However, defence just can't ask any questions that they want to. They can only ask questions relevant to the issues to be decided at the trial. After the defence has asked the witness all of the questions they want to, the prosecution can then ask the witness questions. And these sort of questions are known as re-examination of the witness. When a witness is re-examined, the questions they are asked can only relate to topics or issues that were raised during their cross-examination. Thirdly, the defence presents their case. So once the prosecution has closed their case, the magistrate will ask the defence if they will call or if they will present any evidence. This may include the defendant giving evidence. There's no hard and fast rule about whether or not a defendant should give evidence in a trial. This is a decision that's made on a case-by-case basis. Then fourthly, there's closing addresses. So a closing address is an opportunity for each side to tell the magistrate why they should find in their favour. The prosecution will tell the magistrate why the defendant should be found guilty. The defence will tell the magistrate why they should not find the defendant guilty. Now, the closing addresses will often highlight the following: why the evidence does not prove each of the elements of the offence beyond reasonable doubt, the weaknesses in the prosecution's case, any defences for the defendant raised on the evidence. For example, there may be self-defence or honest and reasonable mistaken belief. Any relevant case law may be discussed. If the defence don't call any witnesses, the prosecution will give their closing address first, followed by the defence. If defence calls witnesses, they will give their closing address first, followed by the prosecution. After each party has given their closing address, the magistrate makes a decision. If the magistrate does not find the defendant guilty of the offence, the defendant will be discharged. The defendant is then free to leave the court, and that's the end of the matter. If the magistrate finds the defendant guilty of the offence, they'll usually sentence the defendant straight away, unless there's a valid reason for the sentence hearing to be adjourned to a date in the future.